Second case on this morning's docket. This is case number 113767, State of Kansas v. Howard Barrett. So I don't disrupt counsel's arguments. I'm going to step out of the courtroom now. Justice Lukert will receive your arguments along with the rest of my colleagues. I should be back in about 20 minutes. I'm not asking you to finish your arguments within 20 minutes. I'm just saying I'll be back then. So please proceed.
Michelle Davis, appearing on behalf of the appellant Howard Barrett. May I please reserve 2 minutes for rebuttal?
2 minutes reserved. Thank you.
So this case began in February of 2008. Mr. Barrett was living in an apartment complex, and the manager was opening the doors to apartments to let the exterminator in, who was spraying apartments. She said she found Mr. Barrett sitting in his bedroom in his lawn chair, which is where he slept, and she said the exterminator was coming, and she left. And then the next event we have is Mr. Barrett's called to 911 where he was rambling. And he said he was in his bedroom sleeping, and a man walked in and came at him with a knife, pliers, and a bug spray thing. And the man attacked him, and he had to defend himself and bring him down. And Mr. Barrett kept asking for an ambulance because he said the man was not going to make it. And so law enforcement responded. They found a knife, and then the bug sprayer next to Mr. Barrett's chair. The deceased had 2 stab wounds to the chest. This is a case where there was a lot of expert testimony. Mr. Barrett had, for decades, been diagnosed with schizophrenia and at times hospitalized. And in addition, it took a long time for him to become competent to stand trial. So he was at state hospitals off and on between 2008 and 2014 when the case finally went to trial.
How contemporaneous was the competency evaluation with the crime? He was arrested quickly after the crime was committed. Was he immediately sent for a competency evaluation at that time?
I think it was pretty quick, but I'm not really sure.
Okay.
And the evidence here,
And initially he was determined not competent.
And they actually committed him twice.
Right, but initially,
right.
the first
Oh, okay.
the first determination was he was sent for an evaluation fairly quickly afterwards, and at that point in time he was determined not competent. Is that correct?
Right, and he went to a state hospital.
Right, for a number of years. Okay.
And then they committed him in January of 2009 to another state hospital. That's right. And we have there was a 911 call. There were the reports of the witnesses at the scene. There was the officer who transported him in the car after he gave him his Miranda warning. Mr. Barrett waived that knowingly and voluntarily. Talked to the officer in the car and then talked to the officer at the station, so that the jury saw how he was rambling and not making sense and not responsive. And the experts testified about schizophrenia and how you can't exercise good judgment, you can't perceive reality from non-reality, your thought process is impaired. It interferes with your ability to make conscious decisions. One expert said you're pretty much robbed of who you are. You're volitionally enslaved, was the words that they used. And then the state had an expert that sort of took a little different approach and agreed that Mr. Barrett suffered from schizophrenia, but said that a fair amount of his thinking was intact, that he acted purposefully, and that his actions were not attributable to delusions, but to rational thought to kill an intruder. And so this is what the jury was weighing. The judge instructed, it was charged as second-degree intentional. The judge instructed second-degree reckless and involuntary man reckless, and also about whether his mental state prevented him from forming the intent or to act recklessly that's required for the crime, the mental state. And the jury came back. The defense requested voluntary manslaughter. The judge explained why he wasn't giving heat of passion, but didn't really explain why he was denying imperfect self-defense. And that's basically
Counsel,
our main
I have
issue
a question
there.
about the request for instruction.
Mm-hmm.
The defense asked for the imperfect self-defense voluntary manslaughter, right?
Not specifically. The defense just said, well, in the instructions request, the written request, yes.
And that was submitted when?
Before, I'm not sure, I believe the state said it was a few weeks before the trial,
Okay.
so I'll go with that.
And then what does the record tell us about what happened at instruction conference?
And
with
at the extraction
defendants?
conference, the defense attorney said, I'm requesting voluntary manslaughter as a lesser offense.
Okay, so it was requested again after, at the instructions conference. And the
Yes,
judge just said, I'm not giving it, and then there was no follow-up objection, right?
right, and the judge pretty much analysis was focused on heat of passion.
And am I right that the Court of Appeals was unanimous that they consider that instruction issue preserved?
Yes,
Okay, thank you.
yes. And the Court of Appeals found that the facts, basically that it was error for the district court not to instruct with imperfect self-defense. And one judge would have found that the error was not harmless, and 2 judges believed that it was harmless. I think the question for this court is, the Court of Appeals applied the test of Roeder, which is the belief is subjective, but the circumstances are viewed objectively. And under that standard, the Court of Appeals said that this instruction should have been given. Because if the circumstances believed to exist had been true, Mr. Barrett subjectively believed, then his use of deadly force would have been justified. There was an aggressor, imminence, and unlawful force. And basically, I guess that's interesting, that interplay then between Roeder and Ordway. Ordway is the case where this court, in 1997, when there was an insanity defense in Kansas, had said that a delusion can't be the basis for imperfect self-defense. Because
That holding from the Court of Appeals there's been no cross petition on that, right? The panel found error, right? Or
Right.
held there was error in not giving the instruction.
I believe so, right?
Okay,
But we
so
filed the petition.
That's a done deal as far as you're concerned today, right?
Right,
Okay,
right.
so all we're really talking about is the application of skip rule.
okay. And so basically, I guess I will proceed to that argument. The Court of Appeals majority found that the jury's finding of reckless conduct, because the jury rejected intentional second and came back on reckless second. And that finding logically forecloses the possibility that a jury would have returned a verdict for, at the time, intentional voluntary manslaughter and perfect self-defense. The dissent said that there should not be this mandatory type application of the skip rule for several reasons. One is that the jury, of course, didn't, you see this where there's premeditation and then intentional second and then a lesser. And this court saying because they came back on premeditation, they wouldn't have come back on an even lesser offense from second degree, and that we don't have that here because the jury didn't reject the lesser offense, actually found that second degree reckless. And then also that we should be looking at the facts of this case, and the jury's verdict did not preclude an instruction on voluntary manslaughter and perfect self-defense, because clearly there were a set of facts here that made that crime applicable. And of course, my argument is that is actually the best crime that fits the facts of this case. The majority Court of Appeals sort of pointed to, did Mr. Barrett have an intent to kill here? You know, he called 911 right away. He was concerned. And of course, you know, you can say there's some facts here that would support that sort of finding this was an unintentional killing. Now, of course, Mr. Barrett stabbed him twice in the chest. To say when you stab somebody twice in the chest that you're not intending to kill them, I think is a little bit of, obviously there's facts here to support that this was an intentional act, an intentional killing. So the part I think that I quibble with on the reckless finding is it's unintentional killing, sure, but then you're supposed to also be consciously disregarding the significant substantial risk and all that. And again, from the expert testimony, you know, that there's not a lot of conscious activity going on here with Mr. Barrett. In any case, and so my argument would be the jury's just trying to find some mitigation here. They were very limited in the options that they had, and so they didn't want to straight out find an intentional killing here, and this was their next best alternative if the jury had been given the option of voluntary manslaughter. That verdict better reflected the facts where Mr. Barrett subjectively believed it, but a jury would question, was deadly force really justified under the circumstances, even if they were true. Well, that concludes my presentation.
Any questions?
Just to clarify on the speedy trial claim, the only argument you're advancing on speedy trial is that the state violated your client's speedy trial rights by not forcefully medicating him in order to keep him competent.
I think it never got to that point because it appears the jail didn't tell anybody. So he comes back in 2010, and they've made him competent, and he decomposes in the jail, and the
Right.
jail notes that he won't take his medication.
But you're not
they
making
didn't-
you're not making an argument that, assuming the timeline. I mean, I don't think the timeline is in dispute, right?
Yes.
And so, assuming all the time that the defendant was not competent is not weighed against speedy trial, you have no speedy trial argument, right? Your only argument is that the state had a duty to keep him competent.
Or at least to alert. The problem is they didn't bring it up. They just
To
let
alert
him
who?
become incompetent. The jail never brought it to the prosecutor's attention. The prosecutor never brought it to the court's attention. They just let it happen. They
Well,
didn't make any
it
effort.
was a refusal by your client to take his medication.
Right, and again, what the defense expert would say is that, again, this is a person who's mentally ill.
Well, are you proposing that the state has a constitutional duty to forcefully medicate people in order to keep them competent? That seems to me to be the logical
But see,
conclusion of your argument.
we never got to that point because the state didn't.
Well, what other
didn't
alternative
notify
is there?
anybody. So I think the only argument that I really have based on this record is to say that the failure of the state here was simply to bring it to the attention, the jail to bring it to the attention.
How does
of the
that
state.
violate his speedy trial rights?
It's a constitutional speedy trial violation and part of the factors.
How specifically does it become a speedy trial violation?
Well, because of the length of the delay, because of this, instead of having a trial in 2010, we have a trial in 2014.
But he was not competent to stand trial.
And the reason for the delay, the reason he wasn't competent is because the jail has physical custody of his body.
I'm just asking you, how would your client have been made competent?
By
Isn't the
jail-
only way
by
for
the
them
j-
to forcefully
yeah.
medicate him?
Well, we don't know that. We don't know what sort of, because they never put any evidence what sort of medical attention he was getting in the jail, right? And so that's the reason for the delay, is that the state didn't properly give him proper medical treatment for that to happen. And that's all that the record allows us, because we're looking back. This wasn't filed until 2014, so. Thank you.
May it please the court, the appellee State of Kansas appears by Stephen Obermeyer as a special assistant Riley County attorney. I would address the first issue raised in the petition for review unless the court had questions about the other two issues. And I just have two comments on the proposed jury instructions and two comments or so on harmless error. And in addressing Justice Byers' question as far as preservation, why are we here? It's because the defendant filed some proposed jury instructions, and at the jury instruction conference just made a statement that we would ask the court to consider voluntary manslaughter as a lesser. Just reading those comment sections of PIC, it seems voluntary manslaughter may be a lesser. That's at page 35 of volume 16. The trial court, Judge Stutzman, focuses on the voluntary manslaughter heat of passion option and spends about 4 pages addressing why he did not think that was an appropriate lesser offense to give. At the conclusion of this ruling, Judge Stutzman asked if the parties have anything further to add or any comments, and there's nothing.
And there was no request at the instructions conference for a imperfect self-defense instruction.
There was not. The only
That came in
reason-
the written request, but it was never made at the conference. Is that right?
Correct.
Not specifically, but it also wasn't specifically heat of passion being requested, was it? After the instruction conference, I would just want to focus on that, because that tells the tale on preservation to me, is whether it was renewed near the close of the evidence at the instruction conference. I mean, I know we have a case that says if it's only pretrial, not good enough. So what exactly was the defendant asking for at the instruction?
Exactly.
Just voluntary manslaughter and non-specified,
That's what was
no,
said.
no accompanying argument.
Correct.
And then didn't ask any questions once Judge Stutzman had done his colloquy on.
That's correct. The judge
Okay.
made that ruling.
Procedurally, because the Court of Appeals treated this as a preserved error, are we stuck with that as our standard of review, since there's no cross petition?
Procedurally, you can consider the proposed instructions. That's what the Court of Appeals considered, so
Well, did the Court of Appeals even address preservation?
I think the Court of Appeals thought the issue was preserved because the defendant filed a request for voluntary manslaughter.
Is that what the Court of Appeals said, or are we speculating?
I believe that's what the Court of Appeals said.
Okay.
It was
I think it
preserved
said that.
because it was
Well,
requested.
it not only said
treated
it,
it
but
as
then
a
it applied the standard of review that would be applicable for a preserved jury instruction that had been requested that had been rejected, right?
Yes.
I mean, I just, and plus I've read page 35 several times. I even have it all colored up, and the way I'm seeing it, and tell me if I'm wrong, the defendant requested one voluntary manslaughter instruction that included both heat of passion and imperfect self-defense. And then on page 35, after Judge Stutzman talks about heat of passion a lot, the defendant still comes back and says, but we want our voluntary manslaughter instruction as a lesser included offense. Seems to me both concepts are advanced by the defendant a second time, not just simply submitted in writing, but advanced a second time. And then Stutzman says, I want to think about this, and comes back and rejects it. And I guess I don't think it's fair that we would then say after he rejects it, you have to do it all over again. The judge has clearly rejected the argument that the defendant made at the instruction conference. Is there something I'm missing in that?
I don't recall on page 35 if they asked for imperfect.
No, all he says is, we want voluntary manslaughter instruction, and they've already requested it with both elements in it. So
Right.
it seems to me that's there, and that's what I thought the Court of Appeals was talking about when I read the opinion. So are you trying to make an argument that we shouldn't be looking at a constitutional error?
I am making that argument, but I think my point is, if this issue is so important for the defendant, why aren't you asking the judge at the instruction conference, I would like imperfect self-defense voluntary manslaughter instruction? Instead of the judge going through the heat of passion and voluntary discussion, any questions from the state, from the defendant? None, Your Honor. That's at page 46. And the reason it wasn't important is because their entire theory of the case is evidenced by calling a psychiatrist, a PhD, somebody else to talk about that he could not form intent, was that their theory of the case was not guilty by mental disease or defect.
So the entire theory of the case is he did not have the requisite mental state to form intentional conduct? And the lesser included offense of imperfect self-defense requires intentional conduct, but based on an unreasonable belief.
And that argument was made in close.
And so it's your position. That's why defendant didn't push that, because it would defeat their defense.
Yes, that is the state's position,
Okay.
and it goes back to opening statements before the jury instruction conference. Defense counsel tells the jury, the state is required to prove intent. We will ask you to return a verdict of not guilty by reason of mental disease or defect.
How is the preservation question in front of us if it was decided by the Court of Appeals and there was no cross petition?
As I read the Court of Appeals opinion, because they had filed a request for an instruction, it was before them.
Right, but how is it before us?
Well, the Court of Appeals considered the proposed instruction, I think.
There was
And
no.
you think the Court of Appeals erred?
I did not cross-appeal that, so.
That's what we're at.
That's what I'm asking. How is it in front of us
Yeah.
since there was no cross petition? on the preservation question?
I think it's in front of you in looking at the proposed instructions that they asked, because those are clearly erroneous, I think. And I'd just like to point out a couple of those. Starting with proposed instruction 8, the offense of murder in the second degree includes the lesser offense of voluntary manslaughter. Instruction 9, if you do not agree the defendant is guilty of murder in the second degree, you should then consider the lesser included offense of voluntary manslaughter. Instruction 9 goes on to tell the jury that the state has to prove that the defendant knowingly killed Thomas James. That wasn't the law back in 2008. It had to be that the defendant intentionally killed Thomas James. This instruction is wrong. We're in clearly erroneous land and would have to argue whether knowingly killed under the 2011 version of the criminal code is the same as intentionally killed under KSA 213403.
Counsel, I'll stop. This is probably my fault, but I'm confused. I thought we were arguing about whether or not the error that the Court of Appeals found not to give imperfect self-defense was reversible.
Yes. And this is part of my argument that it's not reversible because the proposed instructions are erroneous.
Well, but that sounds to me like you're making an argument that there was no error. And we already have an established error, and that wasn't appealed.
I'm arguing if Barrett had won, we're going to give you your proposed instruction, the instruction is wrong. And it incorrectly sets out the elements.
That's not what the Court of Appeals said, right? The Court of Appeals said that the defendant should have gotten an imperfect self-defense instruction.
Yes, the Court of Appeals did.
That's what the Court of Appeals said. And we're stuck with that, right? That a decision of the Court of Appeals is not before us.
I think we're stuck with the defendant's proposed instruction because that's what gave the Court of Appeals jurisdiction to consider the case.
Well, that's where I'm confused because that's not what the Court of Appeals said. The Court of Appeals didn't say should have gotten the defendant's proposed instruction. The Court of Appeals said it was error not to give an imperfect self-defense instruction. Is that right?
I think the only way that we get to that is by looking at their proposed jury instructions. And because otherwise, just to say at the instruction conference, Your Honors, I skimmed the comments and pick, and what do you think about voluntary manslaughter? I think you have to help the trial court out a little bit more than that, especially when you don't say anything when the trial court rules on the heat of passion option of voluntary manslaughter. The defendant argued the court can consider this case because we had a proposed instruction that said imperfect self-defense, voluntary manslaughter. And I'm just following through. They get their wish, they get their instructions. The instructions were probably in clearly erroneous land. The dissent talks about a pick crim third 56.05 alternative B that should have been given. That was nowhere in the proposed instructions by the defense. The defense said you don't consider voluntary unless you have a reasonable doubt as to second degree.
It just sounds to me like you're making an argument about whether there was error at all. How am I misreading your argument or mishearing your argument?
Well, I guess I'm trying to say that it's harmless error because if they'd won the argument and received the instruction they proposed, it wouldn't have changed the result because that was an erroneous proposed instruction. But I will go on and argue the harmless issue. And now that Chief Justice Ness is back, I'll start being persuasive because I wasn't before.
Counsel, let me ask you, in Chief Judge Arnoldberger's dissent, she takes issue with the majority citation to the Robinson case and says that it actually is in opposite and doesn't apply the Skips rule. It actually means that the instruction that was requested in Robinson wasn't factually appropriate. Do you agree with her view of Robinson?
Okay, she said to support such a conclusion in Robinson that although Robinson had repeatedly asserted that he acted in self-defense, the jury was provided a self-defense instruction and rejected that theory. The court did not rely on or even mention the skip rule. I guess what I would say about that, Justice Files, is I don't think the majority mentioned the skip rule in Barrett. The skip rule is an alternative to harmless error. It's can be a common sense issue. It does, but in State versus Plummer,
I don't understand that answer. I mean, I'm looking at the majority opinion, and the beginning of the comment says the above facts. It says this implicates the so-called skip rule, and then it starts talking about the skip rule.
All right.
And and it goes on for another half page. And what Judge Arnoldberger is saying is that Robinson was not decided on the skip rule. It was decided on the fact that the instruction that was requested was not factually appropriate. But we all agree that in Barrett's case, the instruction would have been factually appropriate. And so Robinson doesn't work to defeat the defendant Barrett's argument in this case. I'm just saying, do you think that's right?
I don't know.
Okay.
I guess I would just say is that in State versus Plummer, the court said the skip rule should be reviewed as simply providing a route to harmlessness in those circumstances where the elements of the crime of conviction, as compared to the rejected lesser, necessarily shows the jury would have rejected or eliminated a lesser offense. It's just a route to harmlessness. There's more than one route, whether you call it skip rule, harmless error under 6261. The Court of Appeals found that there were three roads the jury could have traveled down: the intentional road, the unintentional but reckless, or the mentally ill, disease, or defect route. And so that's, to the Court of Appeals, it did not make sense to go from reckless second, unintentional, to intentional voluntary manslaughter.
As a matter of sort of Aristotelian logic, that makes perfect sense. Is it fair to assume that juries function purely on Aristotelian logic?
I don't know what the jury's thought process was.
I mean, but you just, I think, very capably summed up the majority holding below, which is it's not logically consistent to think that a jury that found beyond a reasonable doubt that this was reckless could ever, as a matter of logic, it's mutually exclusive, shall we say, to an intentional crime or to an intentional act. But my question is, can we really impose that sort of mathematical precision on what actually happens in jury rooms?
Probably not. I mean, we don't know why they...
In fact, we've specifically said that logically inconsistent verdicts are not reversible. If they convict of one crime, acquit on another, and under the facts that would be logically inconsistent and contradictory, we've said, so what? Juries can do that.
I think that would be the case. But the other point, and I see I'm out of time, is that the harmless error standard, I think should have, the dissent based the dissent on, I can't find beyond a reasonable doubt that it would have made a difference. As argued in the supplemental brief of Appellee, the denial of a lesser included offense is based on 2234.13 or so, and an error in that, not giving it, would be a statutory harmless error analysis. And that was the entire reason for the dissent, because they had emphasis added to the reasonable doubt language. Under Plummer, as cited in the supplemental brief, it should be the non-constitutional standard of harmless error, and that was the other point I wanted to make on harmless error. I'm out of time.
Mr. Obermeyer, before you do sit down, I have an observation on issue 3, which is the Miranda statements and the capacity to waive. And my initial question to counsel was, it seems to me the competency to stand trial issue was the determination to ascertain whether Mr. Barrett was competent was made pretty contemporaneous with the act. He was arrested, confined, and sent off. If he's incompetent or not competent to stand trial at the time of the crime, at the time he was arrested, how's he competent to waive Miranda? He doesn't have to understand what's going on. How does that work?
I guess all I would say is that the crime occurred on February 14th. The order for evaluation to determine competency was March the 12th. So we do have a little bit of a time lag. But as far as whether there was sufficient, I think that evidence was presented at the suppression hearing, and the judge found that there was...
The judge looked at factors not regarding his competency, but what more about the government actions. Was it coercive? Was it that? But if he doesn't have the capacity to understand what's going on, how does he have the capacity to even begin to understand the implications of what he's doing and waiving? How do we factor that and figure that?
I guess if you disagree with that, you look at what he said post-Miranda. It wasn't very much, because as I recall, he invoked for a lawyer, so he must have known something was going on.
But he made some statements that were allowed in. And
there were some statements allowed in. And I think some of them might have come in by the defense, because if I want to show mental disease or defect, I want to get in this evidence about seeing binary numbers and this other information. But
well, he made some fairly inculpatory statements about what he did.
yes, and you had Dr. Logan's testimony at trial that he acted intentionally. He knew enough to call 911 and explain.
But the definition of incompetent to stand trial, and part of what they do when they're assessing that, they being the professionals, they ask, do you know who the players are? Do you understand what the role of each, and all of that sort of thing? And if they're incapable of understanding that, then they're incompetent to stand trial. And if they're in that scenario, how can they understand you have the right to an attorney? One will be appointed for you. Anything you say may and can be used against you. That sort of thing is contraindicated if they don't understand who the players are and what's going on in court, isn't it? I mean, that's what I think the question is.
I haven't researched the part about a Miranda waiver by a person who shortly after has a competency evaluation. That might be accurate. But there were a lot of statements that he made to the 911 dispatcher, volunteered statements that were pre-Miranda, post-Miranda. He was just stating things to which those statements would have come in. But the post-Miranda, maybe he couldn't waive that. But there was plenty of other evidence given. In conclusion, I would ask this court to affirm the Court of Appeals decision and affirm the defendant's conviction.
Have any further questions? Thank you, counsel.
Thank you.
Just briefly to clear this up, and I know you've probably all looked at the record site from the instructions conference, but the judge starts this out talking to defense counsel saying, your initial instructions, you've proposed this lesser offense. And then the defense counsel says, so he's done this before trial, so you have an attorney going into trial here contemplating guilt for a lesser offense. And most attorneys don't stand up in an opening statement to a jury and say, oh, he's not guilty, but by the way, if you don't agree, find him guilty of voluntary manslaughter. They don't do that. They go for the home run. And then the lesser's there if they need it. And so then he's talking to the judge and he's saying, we would request the court instruct on voluntary manslaughter as a lesser offense. And I'll give you another record site. So the defense has done this before trial. They renewed it at the instructions conference. The judge knows they requested it before trial because the judge references it. You also have, let me see if I can get the record site for you. The state filed a memo before trial. Here it is. It's volume 6, page 10. They filed a bench memo before the trial talking about whether the judge should instruct on voluntary manslaughter in perfect self-defense or not. And their argument was because of Ordway, the judge shouldn't. And that was all there in front of this judge before the instructions conference.
Now, if we assume you preserved, because that's all about preservation, right? Which standard applies? Which harmlessness standard applies? Judge Arnold Berger suggested it was Chapman. Your opponent suggests it's a statutory standard. What's your argument on that?
Yeah, and I think some case law came out from this court around or after the time of the Court of Appeals decision. I think in Roeder, where you said that the failure to instruct on a lesser does not implicate the constitutional right to present a defense, and the state standard applies. And so in my brief, I had argued that the constitutional standard applied, and that's what Judge Arnold Berger relied on, but that was predated. And I think some of these courts, and there was another decision, I think in 2015 by this court that
And your
rejected
rationale that it should apply is that the constitutional right to your theory of defense?
Yes, and that's set forth.
But see,
in my
that's
brief.
counteracted a little bit. We've said, Simmons,
Let's see.
back in 2012, we've said the court's duty to instruct on lesser included crimes is not foreclosed or excused just because the lesser included crime may be inconsistent with the defendant's theory of defense. And so if we're saying that lessers need to be given if the evidence supports it regardless of the theory of defense, it's a little difficult to say that that lesser is constitutionally required because of the theory of defense.
Right, and I think in my brief I argued due process.
Due process.
And I think this court in the case law has rejected that. And then just one other just note I wanted to make, Justice Rosen, is that in this case on the mental disease or defect, the trial court instructed the jury that applied not only to the mental state of intentional, but also to the mental state of reckless. And the jury did not, in order to reject, the jury would have had to return a verdict of not guilty. Those were lumped together. They weren't separated out. So in other words, they couldn't we found reckless because mental disease or defect, we rejected intentional. There was no verdict for that, so we don't know that. There was only a verdict saying not guilty because he lacked intent and also he lacked recklessness.
Do you have any further questions?
No, we would simply ask this court to reverse Mr. Barrett's conviction for reckless second-degree murder and on the basis of the failure to give the voluntary manslaughter instruction.
Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time